Dos.
Okay. Hello everyone and welcome to today's lesson. Before we actually start the presentation itself, I'd like to introduce myself. My name is Biljana Božičkova and I am a level 5 law student at Arden University. We are going to talk about human rights and civil liberties today because I found that this theme is very modern nowadays and is also very important because almost everything that we do in our everyday life is somehow connected with our human rights and civil liberties, and sometimes both. And I am saying almost because to say that everything that we do, it sounds a bit absolute, so I'm just going to stick with almost everything. Today's lesson is a part of my Pro Bono Practice at university as a law student, and the project I've chosen to do is called Public Legal Education. And public legal education is exactly what its name suggests, so it's people like me, students, teachers, educators of any sort, go around schools, community centres, homeless shelters, anywhere that they can reach out to people and educate them about some legal stuff, some things that they feel that this community in particular might need to know more about. And that's why I've chosen human rights and civil liberties, because I feel that we need to be more aware of our rights and how we interact with them on a daily basis. The aim is to allow us to recognize where our human rights might be violated in an everyday situation. So it's to recognize, and the information I'm going to give you today will help you to do your own research and to know where to look for more information to help you in a situation that you might find yourself to be the victim. If we are now gonna So, what is the difference between human rights and civil liberties? These two appear in the heading because even though they are often used interchangeably, they are different. And we're going to see how exactly right now. So we're going to start with human rights. Human rights derive from natural law. This is a topic, a ground that's very long to cover right now, but all I'm going to say is that its motto, so to say, is do good and avoid evil. That's where it all comes from. Human rights are standards which protect our dignity. They are designed to protect human dignity. And every person, regardless of where they are in the world, what they do, who they are, is regardless of any factors. Just because you're a human, you have these human rights. There's no other status that you need to cover so that you have human rights. You have them because they are inherent to all human beings. And as I said, the aim of the human rights is to protect human dignity. Now, human rights and social justice are inevitably linked because they share the same goals. So human rights and social justice is all about preserving human dignity. So for example, if a prisoner in prison is going through withdrawals from drugs and alcohol and they're not given proper health care and eventually this person dies from that withdrawal, from the symptoms, then it becomes the case that they have suffered degrading treatment when they were refused their right to healthcare. Another example, no person should be denied their right to education. So let's say a teenager in school has broke school rules and they've refused to take corporal punishment and they've been suspended from school, say, for 2-3 weeks. They are forbidden to go back to school. They're suspended. Even though in this case the student is his fault that he's had bad behavior in school, he can then say that his rights to education were violated, and therefore the school will probably pay him some damages. And that's under Protocol 2 of the European Convention on Human Rights. And in the UK, under UK law, every public authority has to, which includes school boards, has to make sure that they take into account the European Convention on Human Rights. Social justice, along with human rights, seeks to protect the most vulnerable in their hardest moments. The UK has a long history of protecting people and in providing social support to those who struggle to meet their basic needs. So this could be, for example, systems in place to provide housing to people who cannot afford to have one, or through the NHS, free treatment, free medical treatment, and also the disability allowances that's included in the social support that UK government provides to its people. One very clear example I can give you is the maternity allowance. So if a lady gets pregnant and she, in a few months, she'll go and have a baby. She had a job prior to, an income. Should she lose her job and her income? No, of course not. She needs to, her rights needs to be protected by the government, and it is in the UK. That's why we get maternity pay. So you can go and have baby, and you can choose to go back to your work and keep your income, or you can go and find another job. But still, even with or without job, you're still paid maternity pay. But you're leaving your job doesn't mean you quit your job. You're just on maternity leave, so you still get pay. Another example that's connected to the human rights could be if the local council, in an attempt to support a vulnerable family who cannot afford to have housing, they find a housing facility for them, but then one of them is a disabled person, and the city council has not adapted the place in the right way for this person to use it to its full capacity. So it's not adapted. There's no ramp for them to go up and down. So in this way, the council, in other words, the public authority, violates their right to form a family and to have a family. And sorry, bear with me a second. Violates his right to have and preserve his home and his family. So my point here is that we are dealing with human rights one way or another on a daily basis, sometimes without even realizing that we do. And in conclusion, what human rights are, I'm just going to say they are inherent to all people, regardless of any factors and any status. On the other hand, we have the civil liberties, which are again rights, but they are born from the civil contract between the state, the country, the government, and its citizens and residents. So these are the constitutional rights of every single one of us that are given to us by the government, by Parliament, in order to protect us from necessary interference from the government in our everyday dealings. And I'm saying residents as well, not just citizens, because once you're a resident in a particular country, then that's the country's laws that you have to follow. And for example, civil liberty can be the right to vote, the right to silence, the right to a fair trial, and they are different for every country. In the UK, one such Parliament statute that protects our civil rights is the Equality Act of 2010, which protects us from discrimination on any grounds. Human rights and civil liberties are linked. So, for instance, in the UK, the citizens and residents can enjoy freedom of speech, which is a fundamental right under the European Convention on Human Rights, and that's Article 10. This means that you can publicly disagree with government, or you can take participation in any public assembly, and you are not going to get arrested for that. You can say your opinion out loud without being restricted to what you can say and what you cannot say. But in comparison, for example, in a more of an authoritarian regime, it would be the case that you would still have your human right to free speech, but your civil liberties, which depend on this particular country's laws, can stop you from saying, for example, bad things about the government. And then you can get arrested, prosecuted, and put in prison. And that's going to be absolutely legal. So that's the difference. Human rights are for everybody, civil rights are based on a specific territory, and that depends from that particular government and its laws. And if you are a citizen or a resident, you are obliged to follow these rules. Yes?
Just wanted to ask, like if the people are allowed to speak what they want, this is correct, but what if they break the order and if they disturb the other citizens with their actions? Can they be prosecuted in this case?
Yes, they can, but that concerns a different human right, which is the human right of peaceful assembly. And there's a reason why peaceful is in this phrase, because you are not allowed to breach anybody else's human rights while expressing yours. So that's called a qualified right, because there needs to be a balance between your right and other people's rights. So, for example, if you are in a protest and you use words which would encourage criminal activity, or you engage in vandalism, for example, and you get so excited that you start doing things like that, then this would mean that you broke society's human rights as a whole to keep it peaceful, first of all, and second, for example, if you're in a protest, you're walking down the street, but you decided to get violent and broke someone's fence, then that is violation of his rights. So we will speak about types of rights in a minute, so you will see what I'm talking about. So now we are going to deviate our attention to the European Convention on Human Rights I mentioned. And before we see the articles themselves, I'd like to give you a little bit of history and tell you what that is. So the European Convention on Human Rights is the same as the United Declaration on Human Rights. These two are exactly the same, only that the United Declaration on Human Rights is the American version, and the European Convention on Human Rights is the European version. It's exactly the same thing. And so the Congress of Europe was held in May of 1948 in The Hague, which is in the Netherlands. Exactly 750 delegates were on that convention, on that Congress, sorry. It was a big gathering of some very important and powerful people, leaders of social groups, of academia, of trade and business, and also some political figures too. Winston Churchill himself was there, and he gave one of his famous speeches on human rights on the 7th of May, in which he sort of cemented the idea that we had to have some charter to protect human rights. And a little bit over a year after, in 1949, in the summer, the convention was formally drafted in Strasbourg, France, where is now situated the European Court on Human Rights. It was signed by 47 countries in 1950, which is interesting because although it's a European Convention on Human Rights, not only members of the European Union signed this convention. So there were other countries who felt we want a part of this and we want to implement that into our own countries' laws. Why was something like that discussed in that Congress? It was because post the World War II, we all know about the devastation and something had to be done to prevent such genocide and such inhumane treatment from happening again. What's interesting here is that the UK was the first country to ratify, sign the convention in 1951, and that came into full effect in 1953. As I already said, the European Court of Human Rights is established in Strasbourg, France, and that was on 21st of January 1959. You might notice there's almost over 10 years difference from starting to talk about having a charter on human rights and actually establishing and creating the European Court of Human Rights. So all of these processes, they take time. What's more important is, what does that mean to the citizens? Why is that important is because every person who felt their rights were violated in any way, they now have the opportunity to have their case heard, and there was a supreme law, which would, the convention in this case, which would oblige every one of those countries to take the convention into consideration when making a decision for someone's case on human rights. The convention has influenced lawmaking in the UK specifically. I'm going to talk about UK because we are in the UK. It has influenced it greatly because, as I said, it has to take into account these articles to protect the human rights. So now we're going to see what the rights are, the articles. So I'm just going to read them out loud. Article 1 is an obligation to respect the human rights, and every contracting party, everyone that signed it, shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1. Section 1 means all of these rights. That's Section 1. Article 2, the right to life, freedom of torture and inhumane or degrading treatment. Article 3. Article 4, freedom from slavery and forced labour. Article 5, the right to liberty and security of the person. Article 6, the right to a fair trial. Article 7, freedom from retrospective criminal laws or increased sentencing. Actually, there's a very interesting fact on that Article 7 because, and I think it's very important because freedom from retrospective criminal laws means that if a law is created today, it cannot charge any person for that criminal activity that did the criminal act yesterday. So it's only from today on. So let's say next week they come up with a law that says drinking coffee is illegal. So they can only charge and prosecute people who drink coffee from next week, but all of us that drink coffee today, we are safe. We cannot get prosecuted for that. Then we have the right to respect for private and family life, the one that I talked about earlier. Freedom of thought, conscience and religion, freedom of expression, freedom of assembly, right to marry and found a family, right to an effective remedy and national law, freedom from discrimination, and derogation in time of emergency. Now you've probably noticed 3 of them are in red. It is because Article 1 and Article 13, the UK chose to not implement in their law, only because the UK government felt and proved that there were already laws in place to protect these 2 rights. So they didn't need any supreme law to tell them what to do when it concerns one of these 2. Article 15 is also in red because it's about derogation in emergency. Derogation means they can withdraw from following the convention in time of emergency. Time of emergency refers to, for example, in a time of war. So there are different rules. It doesn't mean that they will break every single rule of these, but it means that in order to protect a big mass of people, they might, for example, use techniques with the help of which they might get useful information to, let's say, prevent terroristic attack. So some of these are justified in time of war. Now, we're going to talk about the types of rights. So not only we have the articles on human rights, there are also different types of rights. So we have absolute, which may never be breached for any reason of any sort. You are not allowed to breach these rights, regardless of if you operate under government orders, if you just an individual who decided to break. You cannot break these absolute rights. Qualified, as I answered the earlier question, is about a balance between one person's rights and another person's rights. So there has to be a balance between these 2, and that's the job of the courts, to find that sweet spot where is finding the equation between one person's rights and another. Restricted or limited, they can be interfered with. but only in specific situations, and we'll have a look in some of these in a minute. I can actually give you an example for the restricted ones. It's, for example, when you get arrested. Your right to liberty under Article 5 is then limited by the police when they are arresting you. And that's absolutely fine, because the right to liberty is categorized as limited. As long as they don't go over their powers, it's fine for them to arrest you, and they do it in the proper way. Couple of interesting facts are freedom of religion is an absolute right. So you are permitted to have religion, opinion, anyone that you like, but the freedom to manifest your religion is qualified, is different. For the same reason I explained earlier, you can go outside and preach to people about God or, you know, whatever you want to talk about, but as long as you don't breach other people's rights and you're not being violent or encourage or engage into criminal activity, you're fine. The next one is the right to free election in the UK is absolute, but the right to vote can be restricted. How can it be restricted is, for example, people who are detained in a prison or in a mental health facility, they are not eligible to vote. But again, not all of them. Some of them can, and these are civil prisoners, for example. So they are civil prisoners and they're criminals. Okay. Civil prisoner is someone who's committed a crime still, but it's not a very serious one. For example, he hasn't paid his parking tickets. So he's still in his right state of mind to make a decision who he wants to vote for. Another example for people who can and are allowed to vote are offenders on home curfew. So again, if you're sentenced to home curfew, you've not done anything that serious. And those who are awaiting trial as well or sentencing, because in the UK it's perceived that you are innocent until it's proven that you are guilty. So you're not a prisoner just yet. You are going through court's trial and your case is not being decided yet. So technically you're not a prisoner. Now I'd like to go back to the previous slide and just try and do a little exercise. Feel free to answer, to speak out. You don't have to, if you don't want to. So remember how we talked about the types of right, absolute, qualified and restricted. What do you think the right to life is? Absolute, qualified or restricted?
Absolute.
That's right, that's absolutely right. It's absolute, and that is one of the main reasons why in the UK there is no death sentence. So whatever you've done, nobody is allowed to take your life for any reason. What about the right to liberty and security of the person? What do you think that is? Absolute, qualified or restricted?
Qualified, maybe?
It is restricted, close enough, but yes, it's restricted. As I said earlier, your right to liberty can be violated in a specific set of circumstances. For example, when you're being arrested. Freedom of expression, what do you think that is? Restricted, qualified, and absolute. Remember, absolute is one that you can never breach. Qualified is a right where you can find the balance, and restricted, it can be restricted in a
One aside?
yes, that's right. Well done. So qualified is because, for example, if you breach someone's right to privacy, and you are a newspaper or media of some sort, when you have your case heard, the court will try to find a balance between the magazine's right of expression, which is Article 10, and the right to privacy, which is Article 8. So you as a person and the magazine, you both have rights. So there needs to be some scale that the courts will outweigh how much these can be breached. Freedom of assembly and association.
I have a question about this.
Yeah.
So if we have a particular case, like you said, with the magazine and some celebrity, let's say, that the celebrity's private life was violated, how the court would decide who has the right? Do they consider if one of the right is absolute and the other one is restricted? Do they follow? Is the decision coming up from if, let's say, the freedom of expression, is it stronger than the freedom of liberty and security of the person? It's not.
No, it's not. So that's the issue. They have to be equalised. But it really depends on the particular circumstances under which the right to privacy was breached. And if you don't mind, I would like to hold on until we have a casework to do, and it's quite similar to your question. So I'm going to answer your question in a minute when we get to that, because it's a little bit more than just outweigh them both. There is no stronger one, but in some cases, one can be heavier than the other, if I can say that. But we'll find out about that in a minute. I think we are ready with the articles. So well done for your answers, and thanks for participating. Now, the Human Rights Act of 1998. So the Human Rights Act implements everything from the European Convention on Human Rights into the UK law. So how does that help the citizens? Is that before the ratification of the Human Rights Act, everyone who felt their rights were violated in some way could go and argue in the Strasbourg court, but only if they had exhausted every opportunity on every level of the domestic justice system up until Supreme Court. And if even after that they felt, no, my rights are still violated, then they can go to the European Court of Human Rights and argue there. But as you can imagine, that's a very, very lengthy process. It takes years, and it takes a lot of money to do that, lawyers and everything. Also, if you think about it, 47 countries signed that convention. That's over 7 million people that potentially could be seeking resolution of their case in the European Court. So it's not very convenient for the people. This is an act of parliament, and it's designed to incorporate the articles of the European Convention of Human Rights. It's received royal assent in 1998, and it came into full force on the 2nd of October of 2000. It would enable people to bring their claims related to breach of their human rights right here in the UK. So there's a saying which is more about the new Bill of Rights, which is currently discussed in Parliament, but I feel that it's very much applicable here, because the saying is bringing rights home. So you don't have to go outside of the UK and pay all that money and lose all that time to even get your case heard. That doesn't mean you get to resolution of your case. It just means you get to have your case heard. and it still might not be the answer you wanted to. The court can still decide your rights weren't violated. But the main thing it does, the Human Rights Act, it requires all public authorities to act in accordance with the European Convention on Human Rights. So every new law that's made has to take into account all of these rights we saw earlier, and has to respect them. So there are several remedies, outcomes, in other words, that you can get if you win your case. So these are either prerogative orders, which can be quashing, mandatory, or prohibitory orders. Quashing orders is something, let's say you have your case heard in the Crown's Court, and then you're not happy with that decision and you want to go to appeal your case, and that decision you will go to the Court of Appeal. And the Court of Appeal, in deciding for your side, can issue a quashing order of the lower court's decision. So that's nullifying or invalidating a decision made by a public authority, which is the court in this case. Injunctions, the prohibitory orders are speaking for itself. It's prohibiting someone from doing something. Injunctions is an order made by the court to prevent someone from doing something which is affecting the other side negatively. Declarations, they are, for example, a declaration of incompatibility can be issued with the Human Rights Act of '98. For example, this lower court, Crown Court or the High Court, has decided under a particular act of Parliament, under a particular law, that your rights weren't violated. But if this act, if the wording of the act under which the court has made their decision is not compatible, does not take into account the Human Rights Act, then the Court of Appeal, the Supreme Court, can issue a declaration of incompatibility, which would most likely end in change of the act they used to decide the first case, or just cancelling the act as a whole. So when the court is making a decision, there's something that's called proportionality test. So put in simple words, it's not going over the top. Which means, for example, you are being arrested, but you're being arrested for crossing the road on a red light. And not only are you being arrested, but you're being prosecuted for that and given 2-year sentence. That's going way too far, where they could just give you a warning, or they can still arrest you depending on how you cross the road. But it's going over the top. That's too much of a restriction for just crossing the red light. And also, in making a decision, the courts have to, or that public authority that broke your rights, breached your right, has to prove that there was a pressing social need. So it was in the interest of the larger public that your right is to be breached. So this could happen, for example, in concern of social security. Again, preventing some massive terroristic attack, or even attack on a specific person, or it was someone who takes part in making laws that have done something bad, then you would want to know about that because he's a political figure, or he's a judge and he decides people's lives. So this could be categorized as a pressing social need. Now, before we get to the case scenario I've come up with, to answer your question earlier, I'd like to point our attention to two of the articles. Article 8, which is the right to respect of private and family life, his home and his correspondence. Again, it is specified that this excludes situations where it concerns national security, public safety, and it has to be in accordance with national laws. Which national laws have to take into account the Human Rights Act, so it's all connected. Article 10, everyone has the right to freedom of expression. Now we're going to have a look at the case scenario. Very similar to what you've asked me. A local celebrity, you can choose one, a singer, an artist, actress, has admitted themselves at a rehabilitation centre to treat their drugs and alcohol addiction. Then the local Yellow Pages magazine has found out about it through the cleaning lady of the facility. She's leaked that information. She probably wanted to gain something out of it, money, profit, something. The magazine appointed a team of paparazzi to cover the story, and when they were not allowed access to the clinic, one of them climbed up the fence and took a picture of that celebrity on the balcony. The story was posted the following week, and when the celebrity was made aware of it, they made a public appearance saying that they will sue for breach of their human rights. So was there a breach of human rights, do you think?
It was.
Correct, yes. And what human right do you think that was?
It's the right to privacy, that you can't go and take barge and just
Perfect,
you
well done.
need to respect their right.
You've been listening. Well
Yeah, and
done.
why is this guy climbing the tree to take pictures?
Exactly. So, yes, there was a breach of
Sell the
human rights.
magazine, probably.
And it was Article 8 under the European Convention of Human Rights, which is the right to privacy and family life. The question is, how can the victim challenge that? And what is the remedy that they can get? So we've already talked about the first two, but there's something I haven't yet told you about. It's called the REP test. The REP test, just bear with me a second. The REP test is a reasonable expectation of privacy. So that is a balancing exercise, same as the qualified right, between one right and another right of two different individuals. So the REP test was established through a case of the supermodel Naomi Campbell and a magazine which is called Mirror Group Newspapers. That was in 2004, and the Supreme Court decided this case. So the claimant, Naomi Campbell, she had made a public statement that she has never taken drugs. Now, the defendant in this case, which is the magazine, has posted pictures of her in exactly a facility like that, in a group meeting for drug addicts. So Naomi Campbell sought damages for breach of confidentiality. Breach of confidentiality will be when the cleaning lady of the facility told the magazine about the person, in our case, was admitted themselves in the rehabilitation centre. So breach of confidentiality, specifically in relation to and with taking pictures of her. Her case was decided in both injunction and damages. If we remember from earlier, injunction is court's order which prevents someone from doing something that's negative to the victim. So what happened was that they've issued an injunction, so no further publications were made by the magazine, and this is what's going to happen in our case. So there will be an injunction issued, but they probably won't get any damages, meaning money paid, because when they made the public appearance, they didn't mention that affected their health in any way. There wasn't any real damage to them apart from being photographed. So if they did say, oh, it's made it so much harder for me to deal with my addiction, and now it's all out in the world and it's affecting my health, then they probably get some money paid. Also, all magazines, all media operates under something that's called Editor's Code of Practice. So under that Editor's Code of Practice, magazines, newspapers, TV, they are not allowed to interfere with people's privacy without consent. And that's includes also taking photographs, and that's under the section 2.1 and 2.3 of that Editor's Code of Practice. So not only they breached the European Convention of Human Rights, but they also broke their own rules, going against the Editor's Code of Practice. Yes?
I have a question, like if this lady was just in the park and somebody takes photo of them, I don't think that their rights are violated, because it's a public place, so
exactly.
Everybody can be there, and if you are on the public place, that means that you don't want to hide yourself.
Absolutely, yes. So, as we said, this is a private facility, and they were expressly denied access to go in there and interview or take pictures of that person. But if you're just walking out in the park and you are a celebrity, there's a good chance someone will photograph you or come and ask for your autograph. Or that's also connected to reasonable expectation of privacy. It's not reasonable to expect when people recognize you out in the street to just go past you and can't talk to you, can't take pictures of you. You are a celebrity. There's
you are in
certain
a public place.
Yeah.
They're gonna
Yeah.
do that.
Also, like if somebody's doing a video and accidentally you're on this video, it's not his problem
Yeah,
that
no,
take a
it's no
video. You are there,
violation
so
then.
you don't
yeah.
need to delete the video or anything.
Yeah, there is something, for example, I go to, with my daughter, we go to playgroups in churches, and before we start the playgroup, they give you this form of consent to sign, where you say, yes, I allow pictures to be taken of my daughter and me, or no, I don't, because even if it's a church, it's still a closed facility where they have to ask me if I want to be photographed or not.
But it's
For
still
several
some kind of
reasons.
public place, I guess.
It is a public place, but there are different.
Restricted.
It's
public place.
restricted.
Mhm.
Yeah,
Yes.
it's not like.
Right.
It is a church where everyone
Yeah.
can go
Yeah.
and attend. But again, there are different programs. This is for kids, especially when it concerns kids. It's a different kind of story. When it's adult, it's not that serious. But when it's little kids, then the guardian or the parent has to be informed and ask consent to take pictures. Where was I? Perhaps we should go to the next slide.
So
So
in
yes,
this
we-
case, at the end, the celebrity won the case, yeah?
Yes, even though the magazine had their right of expression, and again, their argument will be it is in social interest for us to be a free press. Free press is something very important, and often comes to us, free press is what can get society to evolve, often through shocking, disturbing, offensive ways. But that doesn't mean that every single detail of a person's life have to be put out in the public. And as I said earlier, if it was a politician, a judge, someone who's in charge of people's lives, that you might want to know that he is taking some substances and.
Yeah, because in this case, this celebrity, she might be an example for next generation, and in the reality, actually, this person is not a good example. It's abusing with stuff.
Yeah,
So
that is correct. So yeah, so I think we've answered this question. And we're just going to move on to, sorry, before I move on to this case, I just have to warn you that I'm going to show you two real life cases, and one of them is quite shocking. It's the case of James Bolger. You might have heard of that little boy. It was all over the news. There are several documentaries on this case because of the horrendousness of the crime. So little James Bolger here went out to a shopping centre with his mum. So she probably looked away for a few seconds, and then he was abducted from that shopping centre. He was tortured and killed and found 2 days later, body cut in half on a train track. So it's quite a serious, heinous crime. But what's more shocking is that the killers were two 10-year-old boys. So you would think 10-year-old boys don't do things like that. But from human rights point of view, what happened was, their names are Robert Thompson and John Venables. You can have a look at the case if you want to. There are actually pictures of the boy with his mum, and then how one of the boys is grabbed him by the hand, very leisure-like, just walking him out of the shopping centre. They don't know what exactly has happened from that point until he was found, but obviously there was, apart from being found on the train tracks, there was some evidence that he's been tortured prior to. So the two defendants, Robert Thompson and John Venables, were convicted of abduction, torture and murder, and they were put in prison. But when they reached age 18, they were released on parole, which you would think is a big injustice, because a little boy had died. But the court decided that they were no longer a threat to society because of that they were 10-year-old boys. So the age is, they found that is important in this case because they're now 18-year-olds, they are adults now, and they're not a threat to society. I believe now there is somewhere around 41, 42 years of age. Both of them are alive, and one of them has not committed any crimes. He's still on parole, but the other is currently in prison for because when you're on parole, the police and the courts look at you very closely in what you do. So even the tiniest breach of the law, you go back to prison. So they went through his computer, they kept close surveillance on both of them, and went to his computer and found some child pornography on his computer. So that's a big violation, taking into account that he assaulted a 2-year-old boy. He's brought back to prison, but what does that have to do with human rights? It is that the two defendants were given new identities, and the court has decided to issue a ban for everyone that knew about their new identities to ever release them anywhere. And that's in concern of the Article 2 right to life. So there's a big chance if people knew who they were, someone might want to go and hurt them. Even though they've committed this heinous crime, they're still human, and as we remember from the beginning, all humans have human rights, regardless. So this is how human rights are applicable in this case. You might not think that's too much of a justice, but if we want to all be equal, then we have to respect everyone's human rights. The next thing I want to talk about, and we'll finish in a minute, it's treatment of mental health patients. That's a big one because it has changed the way mental health institutions work since the convention. I'm going to tell you about this case about a paranoid schizophrenic serial killer in the UK who was detained in the Brockmore High Security mental hospital. He argued that there was, at the time, there was an act of Parliament, the Mental Health Act of 1983, which said that he was no longer required to prove that he was cured of his mental illness before him being released. So this was an actual opportunity for him to apply for release, and he did not have to be cured. So he could have been released under this act. What happened after is that the Court of Appeal, when he appealed his case and said, I want to be released because I don't have to prove that I'm cured, the Court of Appeal decided that the Mental Health Act is in conflict with the Human Rights Act. So they would issue a declaration of incompatibility, the one that we talked about earlier. And they will completely scratch that Mental Health Act that's concerning him, and they will go by the Human Rights Act. Why are they going with the Human Rights Act? Because releasing this person, the Court of Appeal decided that it might be an issue of social security. So he is not yet cured and yet he might be let out of prison, where he could, let's say, doesn't take his medications. And again, he's a convicted serial killer. So that is directly connected to every one of us. He could go out in the real world and continue to commit crimes. So they decided that this has violated Article 5 and 6, which are right to liberty and fair trial, because liberty and security of the person, we're talking about security of the big mass of people. And fair trial is a breach of fair trial because it's not concerning him, but again it's concerning the larger public. So the larger public, under the Mental Health Act, did not have a say in this case. We don't want this person to be released. This breaches people's rights. I think we are done with the lesson itself. Now, of course, I forgot to mention in the beginning that in front of you found these envelopes in which you have 2 pieces of paper. One is if you wanted to take notes, and the other is a 3 little easy questionnaire. And I'll give you 5 minutes now to go ahead and answer them, or if you can think of something that you might want to ask me, now's your time. Who wants to go first?
Sorry, I just wanted to ask, what's the difference between royal assent and the coming into force?
You're talking about the Human Rights Act. I'm just going to go back a few slides to... Oh, sorry, I might have not mentioned that earlier. Right, that's fine. So this is what you're referring to?
Yes.
There's a difference between royal assent and a law coming into force. So no law in the UK can be passed without receiving royal assent. Royal assent in translation means that the royalty, the king or the queen, the crown, has given their permission for this law to go through all the procedures, through House of Commons, through House of Lords, and then to be signed, ratified, and then, only then comes into force. Once everyone's have agreed. They're happy with the wording of the act, and most importantly, the royal assent is in place. So first, it gets royal permission. The king now would say, "Yes, I'm happy with this." Then, why there's two years difference is because it takes time. So a law would start in as a bill, just as a bill. This bill then goes to the House of Commons, and then 3 different sections in which 3 different discussions happen for clearing, improper wording or anything that might be ambiguous. And then once that's done, it's being sent to the House of Lords. Then the same 3 stages happen there, and after that, everyone signs it. Once they're all happy, that's the law they want to create. And then that's when the date of signing is when it fully comes to force. But the date of royal assent is going to stay in the name of the act. Anybody else questions?
I have a question, and I'm going to add because you said European convention is the same as the American one.
Yeah.
If I do a crime in America, does it mean that I'm criminal in Europe as well?
It depends what crime you commit, and well, if it concerns human rights, you will be, because you are doing it in the United States, you will be prosecuted under their local laws. And you will be, for example, sentenced by their own laws. You won't, if you come back here, they probably won't let you go out of the US. But if they do, and you come here, you will be brought back to the US.
No.
Unless you are from a different country, and then your embassy can issue, I don't remember actually what it was called, a document which would want you back.
Extradition.
Some sort of an extradition document where they can ask the US government to let you serve your sentence in your home country.
So if somebody did a crime in some country that doesn't obey the rules of the European Convention and then goes to Europe, does mean this person is not going to be prosecuted?
No, it means that he will be prosecuted under the United Declaration on Human Rights, which is the American version. So that's valid for every person, every country, every continent, and since it's not in Europe, it will probably go under the United Declaration on Human Rights. Anybody else? Yes.
So I have a question for you. What is a public authority?
Oh yeah. So public authority, I've talked about it the whole time, but I've not explained what that is. So it's public authority is any public body or any body who exercises public actions. So this could be your local council, school board, as I mentioned earlier, if it's a governmental school. If it's a private, then that's not included. If it's the NHS, prison governors, who else? Anyone that exercises engages in the courts. Actually, that's a very important one. The courts, because your rights can be breached by a public authority, but not only. So it could be between individuals. You can breach my rights, and then I want to go to court and argue that. And what's going to happen is then the courts, in deciding their case, they play the role of the public authority. So they are the one that are obliged to follow and incorporate the human rights in their decision. Can't think of any other public authority. So yeah, prison governors, school boards, the NHS, councils, some charity trusts as well, like the U Trust, because that's governmental institution.
Basically, whoever works under the government or whoever
Yeah.
works for government
Yeah,
or like public
and yeah,
services.
everyone who exercises public action. So it could be something private, but as long as they're
Mostly is this. public.
acting as in support. So, for example, there are several housing places where you could get assisted housing. They're not from the council, but they still exercise a public action.
Yeah.
Right. Okay. I think we are done. Let's just have a quick look if we've gone through everything. Oh, just one last thing. I would just like to read this citation from that's Eleanor Roosevelt. You see there, which we all know. She's a very big activist on human rights and former First Lady of Theodore Roosevelt. I'm just going to quickly read it out. Where, after all, do universal human rights begin? In small places, close to home, so close and so small that they cannot be seen on any maps of the world. Yet they are the world of the individual person, the neighborhood we live in, the school or college he attends, the factory, the farm or office he works. Such are the places where every man, woman and child seeks equal justice, equal opportunity and equal dignity, without discrimination. Unless these rights have meaning there, they have little meaning anywhere. Without concerted citizens' action to uphold them close to home, we shall look in vain in progress in the larger world. So this is kind of cementing everything that I've said. Human rights are all about preserving human dignity and respecting one another. Do good and not evil, as per natural law. So that's it. I thank you for coming today. I appreciate you being here. You can answer your questions. I can collect them at the end. And that's it for me. Thank you.
Thank you.